Yeah, so the word appeal has not been defined anywhere under BNS or BNSS. However, it can be described as the judicial examination of a decision. Please underline, judicial examination of a decision given by the lower court by a higher court. The Merriam-Webster dictionary defines appeal as a legal proceeding by which a case is brought before the higher court for review of the decision of the lower court. So whatever the decision is passed by the lower court for review, we go to high court. Now section 413. No appeal shall lie from any judgment or order of a criminal court except as provided by this Sahita or by any other law for the time being in force, provided that the victim shall have the right to prefer an appeal against the order passed by the court acquitting the accused or convicting for lesser offences or imposing inadequate compensation, and such appeal shall lie to the court to which the appeal ordinarily lies against the order of conviction of any of the court. So if the, for example, if a person by lower court is convicted only for a period of 3 month imprisonment, and the victim feels that the punishment is very less, so in that case also the victim can file for appeal. Now section 414. Any person who has been ordered under subsection 136 to give security for keeping peace and good behavior, who is aggrieved by an order refusing to accept or reject sureties under 140, may appeal such order against the Court of Session, provided that in this section shall apply to the person the proceeding against whom has been laid before the session judge, and it will be in accordance to the provisions of subsection 2 of section 141. Okay, so if you are aggrieved by any of the order, for example, refusing to give security for peace and good behavior, or who has refused to accept the sureties that are given under this, in that case you can file an appeal. Now section 415. Any person convicted on trial held by the High Court in its extraordinary original criminal jurisdiction may appeal to Supreme Court. So if you are not satisfied with any of the decision that is passed by the High Court, in that case you can appeal to the Supreme Court. So any person convicted on trial by the Session Court or Additional Session Court may by the other court in which the sentence of imprisonment is more than 7 years have been passed against him, then the person convicted at the same trial can appeal to the High Court. So see, for my when you are talking about Court of Session, it is based on respective districts. Okay, so when you from Court of Session you can appeal to High Court, from High Court you can appeal to Supreme Court. So this is the forum. So any person who has been convicted on trial held by the magistrate of first class or second class, or by the sentence under section 364 or in respect of whom the order has been made or a sentence has been passed under section 401 by any magistrate. So in that case, all these cases you can appeal. Now section 416. Notwithstanding anything contained in section 415, where an accused person has been pleaded guilty and has been convicted on such plea, then no appeal shall lie. So for example, you have already plead guilty. Remember when we were talking about if a person pleads guilty, then it will be punished. If he does not plead guilty, then the trial commences. So for example, if you have pleaded guilty, so in that case no appeal shall lie. If the conviction is by the High Court, if the conviction is by the Court of Session or magistrate of first class, except as to the extent of the legality of the sentence. For example, if the sentence is only illegal, so in that case the appeal will be allowed. Now 417. Notwithstanding anything contained in section 415, there shall no appeal by a convicted person in following cases. First, where the High Court passes only a sentence of imprisonment for a term not exceeding 3 months, or fine not exceeding 1000 rupees, or both such imprisonment and fine. So where the Court of Session passes only sentence of imprisonment for a term not exceeding 3 months, or fine not exceeding 200 rupees, or both of such imprisonment and fine. Now next is where a magistrate of first class passes only a sentence of fine not exceeding 100 rupees when in case tried summarily and a magistrate empowered to act. So in all those cases where the fine is very less, in those cases appeal is not allowed. Now 418, save as otherwise provided in subsection 2, the state government may, in case of conviction on trial held by the court other than the high court, direct the public prosecutor, please underline, direct the public prosecutor to present an appeal against the sentence on the ground of its inadequacy to the court of session if the sentence is passed by the magistrate, and to the high court if the sentence is passed by any other court. If such conviction is in case in which the offence has been investigated by an agency empowered to make an investigation into the offence under the Central Act other than the Sahita, the central government may direct the public prosecutor to present an appeal against those sentence on the ground of its inadequacy to the court of session or the high court, as the case may be. Okay. Hello. Hello.
Hello, ma'am.
Yeah. Next is 419. Save as otherwise provided under subsection 2, the subject to the provisions of subsection 3 and 5, the district magistrate may, as the case may be, direct the public prosecutor to present an appeal to the court of session for an order of acquittal passed by the magistrate in respect of cognizable and non-bailable offences. For example, there is a murder trial going on, and in that case the person is acquitted. So what will happen? The district magistrate may direct the public prosecutor to present an appeal to the court of session for an order of acquittal passed by the magistrate, directing the public prosecution to present an appeal to the high court from an original or appellate order of acquittal passed by the court other than the high court not being under clause A, or an order of acquittal passed by the court of session in revision. So in that case the appeal lies. Okay. If such an order of acquittal is passed in the case where the offence has been investigated by an agency empowered to make investigation into the offence under any central act or other than Sahita, the central government may, subject to the provisions, direct the public prosecutor to present an appeal to the court of session from an order of acquittal passed by the magistrate in respect to a cognizable and non-bailable offence to high court for original or appellate order of the acquittal passed by the court other than high court not being an order under subclause A of order of acquittal passed by the court of session in revision. No appeal to high court under the subsection 1 or subsection 2 shall be entertained except with the leave of the high court. Please underline the word leave of the high court. Leave means permission. Okay. Now section 420. So where the high court has on appeal reversed an order of acquittal, please underline, of the accused person and convicted him and the sentence him to death or imprisonment for life or any imprisonment for more than 10 years, then he may appeal to Supreme Court. For example, if the lower court in murder case has released you, but when in high court they saw that no, it is important matter and they have sentenced you for 10 years or imprisonment for life or death, in that case you can always go to appeal for Supreme Court. Then 421, notwithstanding anything contained in this chapter, when more persons than one are convicted in one trial, and an appealable judgment or an order passed in respect of any of such person, all or any of a person convicted at such trial have the right to appeal. For example, 5 persons are convicted for murder, then all the 5 persons has the right to appeal. Either they can go jointly or separate. Okay. Now 422, subject to the provisions of subsection 2, an appeal to the court of session or session judge shall be heard by the session judge or additional session judge, provided that the appeal against conviction on trial held by the magistrate of second class may only be heard and disposed by the chief judicial magistrate. An additional session judge or the chief judicial magistrate shall hear only such appeal in the session judge of a division as may be specified by the special order or as the high court may deem fit.
Yes, ma'am.
Yeah. Now section 423. Every appeal shall be made in form of a petition in writing presented to the presented by the appellant or his advocate, and every such petition shall be accompanied with a copy of judgment or order appealed against. Please underline. Now 424. So if the appellant is in jail, he may present his petition or appeal and copies accompanying the same to the officer in charge of the jail, who shall thereupon forward such petition and copies to the proper appellate court. Now 425. If upon hearing the petition of appeal and copy of judgment received under subsection 423 and 425, if the appellate court considers that there is no sufficient ground for interfering, then it may dismiss the appeal summarily. Now 426. If the appellate court does not dismiss the appeal summarily, it shall so cause notice of time and place of at which such appeal will be heard to the appellant and his advocate, to such officer as the state government may appoint it in its behalf. If the appeal is from a judgment of conviction, then the case is instituted on the complaint, then to the complainant. If the appeal is under section 419 or 420, the accused and shall furnish such officer, complainant and the accused with a copy or grounds of appeal. The appellate court shall then sends all those documents. Okay.
Yes, ma'am.
Yeah, I think here one line is missing, so I will cross check and let you know. Okay. Now 427. So after perusing the such records and hearing the appellant or his advocates, if it appears that the public prosecutor or as the case may be, this case under appeal under 418 or 419, the accused, if he appears that the appellate court may, if it considers that there is no sufficient ground, please underline, if there is no sufficient ground for interfering, then it may dismiss the appeal, or may, in an appeal from an order of acquittal, reverse the order and direct that further inquiry to be made and the accused be retried or committed for the trial as the case may be, or find him guilty and pass sentence on him according to the law. Then in an appeal from conviction, reverse the findings and sentence and acquit or discharge the accused, or order him to be retried by the court of competent jurisdiction subordinate to the appellate court, or committed for trial. Or third, alter the findings, maintaining the sentence, with or without altering the findings, altering the nature of extent and the sentence, but not so far as to enhance the same. Now section 429. So whenever a case is decided on appeal by the High Court under this chapter, it shall certify its judgment or order to the court by which the findings, sentence and order appealed against was recorded or passed, and if such court is of the opinion that the judicial magistrate other than the chief judicial magistrate, the High Court's judgment or order shall be sent through chief judicial magistrate, and if such court is of the opinion that the executive magistrate, then the High Court's judgment or order shall be sent through the district magistrate. So this is the process how the judgment will be sent or delivered. Now 430. Pending any appeal by the convicted person, the appellate court may, for the reasons to be recorded in writing, order that the execution of sentence or order appealed against be suspended, and also if he is in confinement, then he may be released on bail or on its own bond. The power conferred by this section on the appellate court may be exercised only also by the High Court in the case of appeal by a convicted person to the court of subordinate thereto. So this is only this right is only exercised by the appellate court. Please underline the word appellate court.
Yes, ma'am.
Yeah. 431. Where an appeal is presented under section 419, the High Court may issue a warrant directing the accused to be arrested and brought before the subordinate court, and the court before which he is brought may commit him to the prison pending the disposal of the appeal, or admit him or release him on bail. So there are two situations, either they will release him on bail or they will put him in jail.
Yes, ma'am.
Now section 432. So in dealing with any appeal under this chapter, the appellate court, if it thinks additional evidence is necessary, shall record its reason and may either take such evidence itself or direct it to be taken by the magistrate, or where the appeal court is high court, then by or by the court of session or by the magistrate. For example, in the lower court all the evidences has been recorded and the judgment is pronounced, but in appeal you wish to give some additional evidence, for example any recording you found. So in that case, under this section only the order will be delivered by the magistrate to give additional evidences. So where the additional evidences is taken by the court of session or the magistrate, if or he shall certify that such evidences to the appellate court, and such court shall thereupon proceed to dispose the appeal. The accused or his advocate shall have the right to present when the additional evidences is taken. The taking of evidence under this chapter subject to the provisions of chapter 24 as if it were in inquiry. Now section 433. So where an appeal lies under this chapter is heard by the high court before a bench of judges, and they are divided in opinion, the appeal with their opinion shall be laid before another judge of the court, and the judge, after hearing as it deems fit, shall deliver his opinion, and the judgment or order shall follow that opinion. So whatever the opinion will be given by him, that will be followed as a opinion, and that will be delivered as a judgment in appeal.